past quite a lot. So we are becoming quite familiar with each other's kind of styles and how we approach work. Sometimes we do approach work quite quickly, and we might look at different employment issues from a different angle, which is often quite useful to see it from somebody else's perspective. So as you all know, Nikki is the managing director of Inspired HR and often puts on lots of great events for everybody to get more into, get a better insight into HR, and to also just to bring business together in order that people can share her knowledge and we can all grow together, which I think is a great idea, and it's a great business model that you've got, Nikki. So I'm pleased to be invited along to come and do this talk today again, and hopefully we'll do more in the future because there's too much to talk about in an hour and a half.
There is. Okay, so we've got quite a lot to cover, so we're going to move forward. Kat's going to start by talking to you about the Employment Rights Time Bill and generally an overview of the Employment Rights Bill. Before she does that, I'll just make you all aware of how we've structured this presentation and the way we're doing it. So we did a previous presentation about the rights to work, the Make Work Pay Bill, when they started talking about what might come. So we've actually kept it in the same structure, and we're talking about the same things because we talked about what may be coming and what we think it may look like. So we're now kind of talking about what does that now actually look like. Now there is a lot. I mean, just looking at the fact sheets and the bill itself, I had over 300 pages, so we're not going to cover everything, but it'll be very top line. And as Zoe said, there will be things sent out. So handing over to you, Kat.
Nikki. Yeah, so really just brief overview as to the Employment Rights Bill in general. So as if you're all on this webinar, you must have heard about it by now. So it was introduced in October, so not too long ago. It was 158 or so pages long. There were 24 impact assessments, lots of consultations, additional documentation that went along with it, and it did run to some 300 pages plus. And it is quite thorough, but still leaves a lot of work to be done. There's a lot of proposals that have been made that do need further consultation, that do need further explanation. There's lots of things that haven't been defined yet. There's no structure in place. And ultimately, although we're talking about it now in 2024, the changes are unlikely to come into place until 2026. So we've still got some time for things to change massively. So today, what we're going to be talking about is currently what the bill proposes and what government have said they intend to do. Now, of course, from September, when we had our first webinar up until now, things have already changed quite a lot. So I suspect that over the next year and a half, we probably are going to see more changes and have more discussions. But as we're standing, it's currently in the committee stage for the bill. It's going to the Houses of Commons in January. And then, as I say, the intention is that it'll be enforced sometime in 2026. And currently, I don't know if anyone's been watching the news about it, but they're saying that they estimate these changes are going to cost businesses around £4.5 billion to implement. So in order to do that, they have to make sure they get the changes as right as possible. So I think that's why it's going to take even longer than we first expected, because there's going to be such a huge cost. And it's the biggest overhaul of the employment law legal framework in generations. So it's a huge task. So bear with us when we're going through, because there are quite a lot of changes and it's not always as straightforward as we would like it to be. But as Nikki said, last time in September, if anyone was present then, we did pick out some of the key topics that we were interested in. So what we're going to do is talk about those, because those topics were more suited to small businesses, SMEs, and they were suited to the areas that me and Nikki often work in. So I'll pass you back to Nikki.
Thanks, Kat. And you're right, it is the biggest changes in generations. I mean, obviously we've gone down a lot of rabbit holes researching this, the documents and everything. And one of the phrases I actually come across is that basically the Labour government are rolling back employment law to 2010, prior to the Conservative government making all the changes that they did. So it's rolling back. But, you know, even though we will cover a lot of this off, we both know there's a lot of work to be done. And we know from when they brought in, you know, the holiday pay and a lot of the other previous legal changes, there was errors that we were still trying to correct years later. So this amount, we know they're not going to get it right, and there still will be a lot to do, even once it starts to roll out. So we're going to start with talking about when they did the work pay document, they had a section that was all around ending one-sided flexibility. And around that flexibility, we've kind of got a few subjects that we talked about. So I'm going to start off by talking about the 0-hour contracts and what does that mean. Now, 0-hour contracts primarily are used within retail, hospitality, the care sector. They tend to be the areas that they tend to use. And I know a couple of years ago when we had the holiday calculation changes come in, you know, we very much recommended try and stay away from these where possible. Make sure, and if you do need to use them, make sure they're genuine, because of the way that the 12.07 holidays went to 5.6, and then they realised they'd made a mistake and took it all back again. So there's always been a challenge with 0-hour contracts. Now, the government have never liked 0-hour contracts, and they did initially say that they were looking at getting rid of the 0-hour contracts. However, now they're actually going to be making just a number of changes instead. Now, when we went through this guidance, 11 pages of guidance on 0-hour contracts, and the guaranteed hours around it. It's very complicated. There's still a lot of work to be done, but it's basically intended to offer stable hours based on a working pattern that we believe is going to be over 12 weeks, but that's still to be confirmed. And also that there will be a minimum guaranteed hours on the back of that. So it's not going to affect just people who are on 0-hour contracts at the moment. It's also going to affect people that are on low guaranteed hours. I know when I worked in retail, we had some stores where we had people on 4 hours, where they had an hours challenge and we had to do a big change of hours, and people were put on 4 hours, 8 hours, 12 hours. So the government still have a lot of work to do, but it's going to replace the predictable hours changes, which the Conservative government had been talking about. And obviously that was pulled by the Labour government. And one of the first areas that they're going to be talking about is the right to guaranteed hours. So this is where it's going to reflect the average hours of a particular reference period. Now, we believe that the reference period is going to be about 12 weeks, and that's kind of already the time period we work to anyway. When we have conversations with clients about putting where an employees might have asked for guaranteed hours, or they're looking at what do they need to put them on, we always say the 12-week reference is kind of what you should be using. So we do believe it's going to be the 12 weeks, and that's expected, but they've actually not confirmed it yet. Now, with 0 hours, not all employees want to have guaranteed hours. They're quite happy having the flexibility around 0-hour contracts. So they do actually have a right to refuse those minimum guaranteed hours if they don't want them. And it is going to apply to all contract types. And, you know, we also believe it's going to affect the agency workers. Again, there's still a lot to be defined around that, but it's also looking at affecting agency workers, which is going to have a massive impact on those temp agencies that do a lot of temps. There's going to be a minimum amount of hours that is still to be set by the government, whether that's 4 hours, 8 hours. We don't know what that's going to look like at the moment. And interestingly, what's going to come out of the result of that is that an employee will actually have the right to bring a claim if they feel that the hours you've given them are not correct and they actually should have been offered more based on their average. So, you know, that could, and again, that will link into some of the things we'll talk about. There's also going to be a right to reasonable notice of requirement to work a shift. So, and what that reasonable notice to work, we don't know what that's going to look like at the moment. I mean, in basically 59% of employees currently on 0-hour contracts are actually normally only given less than a week's notice of the working hours. Now, we know from a life point of view, that's really hard sometimes because we all have life and plans, but there is going to be a right to a reasonable notice, requirement notice to what notice you give them around their shifts. It's very complicated, still to be defined. There's also going to be a right to a reasonable notice period of a cancellation of shift. And what actually will link to that as well is that there will be a right to a payment when a shift is cancelled, because obviously at the moment, we know in reality, people are quite often sometimes told on the day that they can't have the shift, or just before 24 hours notice. And there will actually be a payment linked to that. We think it'll be capped at the shift payment, but what that looks like again is still to be defined. And the right to cancel cannot be more than 7 days. So you can't give them, they can't expect more than the government will not cap it at more than 7 days of notice to cancel. Now, there's also going to be rules around agency workers, again, still under consultation, and it will be the responsibility of the agency to manage that. We need to consider also how these minimum hours will actually impact the temp to perm fees for agencies where they're using them. So there's quite a lot going on around 0-hour contracts, but in summary, they'll be entitled to reasonable notice of a shift and cancellation. They'll be entitled to payment for a cancelled shift, and they will be entitled to minimum guaranteed hours if they're working regular hours for you. Very complicated, but there's no point in going into further detail on that at the moment.
I think also, I think the takeaway from everything that we talk about today, the theme that's going to run through it is that everything still needs consultation. So when they're talking about the relevant period, is it going to be 12 weeks? When they're talking about definitions of particular, what notice period do they mean and how much payment should be made? Nobody knows. So as soon as we find out, of course, we will share that information. But I think that will be a theme that goes on every time we say something we're going to be saying.
It will. Yeah. Still under consultation, still to be defined.
I was going to go on to the fire and rehire, and this is quite a short update, really, because again, we did discuss this in September. So fire and rehire, for anybody who isn't aware, is the practice where an employer dismisses an employee in order to offer them a new contract on less favourable terms. And that practice was happening. It sounds strange when you say it out loud, because of course you would want all employers to be reasonable and for a real conversation to be had if the contract needed to be changed. But some businesses do that, and then when the employee doesn't want to re-engage, there's a real issue there that they've lost their employment and the practice has been unfair. So in July, the government did introduce a code of practice all around fire and rehire, which does give guidelines about what can and cannot happen. But this bill is proposing that actually that will be an automatically unfair reason if an employee is dismissed because they refuse to vary their terms of contract. And so it's more about employers now being aware, now, even though this change isn't going to come in until, as I say, 2026 probably, it's important now that as employers and as businesses, we're looking at, are our contracts correct? What are the terms that we've got agreed between the parties? Are the terms clearly defined? Do you have a clause within your contract which specifically allows you to make changes? What notice period do you have to give? Do you have to consult? All of those things now are things that we can be doing now to make sure that the contracts are as watertight as possible, so that in the future, although you can't dismiss an employee who refuses to vary the terms of their contract, currently, it would be better that you have all of these things in place to allow you as much flexibility as the law is going to permit. So it is more of a kind of a time to take stock and review contracts now, but in the future, it will make it more difficult to dismiss if you did want to vary the terms of their contract. And so it's only a small change because the code is already in existence. So again, we will keep you up to date.
Yeah, and I mean, with fire and rehire, Kat, I mean, I've been in HR 33 years and I've been in business 8 years, And the fire and rehire, to be honest, with the SMEs that we've used, we've never needed to do it, because a good business will always sit down with individuals to talk about the need for change and things like that. And normally people are very supportive and will change. I have worked in corporate, so where they have done fire and rehire, primarily where it was on retail, and I know they've been some of the biggest challenges and industries that have done that recently and really kind of caused some very big claims against them. As we know, and there's some big court cases going on with some of the retailers at the moment around that. We tend to find in the SMEs, we do the variance, as a document and contract provider and statement in particular, we always have a clause around relying on a variation clause within the contract. But even we still come across some internet found contracts and new clients that come into us and they don't have these and they want to change people's hours. So yeah, and I think linking to that as well, I think what's going to link to the fire and rehire is, and I know we're not going to touch on that massively, is where the variation of hours challenges are going to come into play. We're starting to foresee some real challenges around being able to change people's working hours in the future as well. So it's going to be a tough one, that one, I think, without realising.
And the bill does provide that employers can, that the practice of fire and rehire isn't completely outlawed to an extent where if there is a reasonable, a real unavoidable need of the business from an economical point of view, that this is unavoidable, they do need to make employees redundant, but can offer other terms in the future, that practice isn't being outlawed entirely. What the government are saying is there must be a demonstration that the business had financial difficulties, that there is an unavoidable need. And unfortunately, businesses will get into that position, but it's about making sure businesses and employees know what their rights are and know where the parameters are, where they should stay, and the lines. And I think that'll be the difficulty, really, especially for the larger businesses, as you say. SMEs, not so much, because actually, you are a lot of the documentation, especially with clients that we've been dealing with, the documentation's there, the variation clauses are there. There is what can be given the parameters that we're working in. So I do think to be mindful of, but it's not a huge change because actually we're already supposed to be adherent to these practices in any event.
And the government brought it in basically on the back of what happened with P&O, because that was just shocking. I mean, even from a HR professional point of view, I wouldn't want to have them on my CV at the time that happened. That's certainly not a CV I'd like to be putting into a business. So I get why they did it, because that really affected a lot of people. Okay, so I'm now going to talk about day one rights, which is effectively the 2-year unfair dismissal time limit that we all talk about. Now, this is the one for us that as an SME market is absolutely critical to what we do. People will hear us refer to something called short-term dismissal. So we all know this is a practice that we tend to use quite easily when an SME takes on a new employee, it's not working out, but it's quite easy to exit somebody under short-term dismissal without having to give a written reason, without having to give a reason. Now, obviously, we would always do that if we think they might link it to something else that they might try and claim on. But generally, this gives us the freedom within the SME market to exit somebody very easily within the first 2 years when there's not a risk of another thing that may arise or bring a tribunal claim outside of unfair dismissal. And this is the one that I know when I talk to the team worries me. So now, interestingly, when I did the research on this, Kat, I didn't realise that the government already had the power to actually remove that 2-year time limit on unfair dismissal at the moment. I thought it would have to go through all this big process and everything that we're currently going through. But I actually discovered that if they wanted to, they could actually just remove it. And at Christmas this year, remove it and bring in day one right straight away. But actually what they are doing is tying this in with the legislation and taking this much longer view of getting it right, which I hope they do get it right. Now this...
saying autumn 2026 for when they suspect that it'll go from 2 years to 1 day, which is a huge change. But I think 2026 is when they're saying it'll come in.
It is, and I think they actually need that, because actually businesses are going to have to get ready for this, because at the moment, we all talk about probation periods, but the reality is that because of that 2-year time frame, probation periods in reality in the SME market aren't always worth the paper they're written on, unless you've got a very long policy and process like they have in the big private sectors and public sectors, where probation really is that they tend to not sit on that short-term dismissal outside of probation. But in the SME market, it is commonly used outside of probation periods. So, I mean, the government are bringing this in because they're saying it will support 9 million people to give them job security and feel more comfortable. But this is going to bring some big challenges for business, where they are going to have to be watertight on their probationary periods. They're going to have to be watertight on their recruitment and really make sure they're recruiting the right people. It will only apply to employees and not workers at the moment, but they're basically getting rid of the 2-year qualifying period for unfair dismissal. Now, there's obviously still consultation in 25, and as you said, it's not going to come into place until autumn 26. So this does give us time to work with our clients and really make sure, although we've got probation periods and processes in place, it'll really give us time to make sure that they really start to use them and not rely on this short-term dismissal period now. So the right to unfair dismissal from day one instead of from 2 years will actually only apply as well if they actually start work and the role's not been retracted. So they have to have started work. So again, that's where you've got to be very careful that they've not started work 9 a.m. on that Monday morning, because that day one right will actually kick in, if you have any worries. Now, what's interesting is when I read the bill, where we refer to probation period, they've actually referred to it as an initial period of employment within the bill. So they're actually referring to it as a different thing. Now, we believe, stated within the bill, it says their preference is of a period of 9 months as the initial period. But obviously, that's not confirmed, and that is still to be, agreed and everything. But what's also interesting is it also talks about, and again, this is to be confirmed, that there will actually be a different compensation for that initial period of employment to the normal compensation for unfair dismissal and other matters as well. Again, to be confirmed, but they do touch on that. And fair dismissals will not be prevented. You will still be able to exit an employee or terminate them during that initial period, but it must be for a fair reason. And what the fair reasons include conduct capability, statutory ban, some other substantial reason related to the employee, but cannot be redundancy. And redundancy is actually missing from that list as well, interestingly. So there's still a lot of work to be done on it, but it is worrying me that it's going to become really so much harder to exit somebody and what that might look like. Now, what will change is that actually when you do exit somebody during that, as they refer to, initial period of dismissal, it will actually now have to be put in writing, whereas at the moment there's no obligation other than saying, further to the discussion today, we confirm you've been terminated. They will actually have to, in the future, actually state why that person's been dismissed, because it will have to come under a fair reason. And that obviously also helps people determine whether they have been dismissed fairly or not. Now, what's interesting is, again, when I've looked at this, one of the reasons must be subject to a reasonableness, and this is obviously where you come in, Kat. You would always look at as, is the reason reasonable test, and it will have to be put in writing for that to be identified. It won't affect the 2-year requirement for redundancy payment. People will still have to have 2 years service if they're made redundant for a redundancy payment on top of the notice. Now, ACAS are expected to produce a initial period code of practice, the same as they do for disciplinary and grievance, all this initial code of practice that must be followed. So we're waiting to see what that looks like. And that actually will define what probation periods and initial periods of employment will look like from a process point of view. Another thing that I picked up on as well is when I had a look at the benefits and perks around initial periods of employment, they're actually saying it's still okay that, whereas at the moment it's common to kind of go, you won't be entitled to company sick pay, or you won't be entitled to this until you're outside your probation period, and that is often aligned to the probation period, it will actually still be okay to have longer periods outside of probation to say when perks or benefits might be implemented. So if someone says you don't get entitled to full sick pay until you've got 12 months service or whatever as an example, and that will obviously sit outside of the initial period guidance, that's still okay. So the biggest things I guess coming out of this, because this is the one where it's going to be very challenging for the SME market, private and public not so much, because they already kind of operate as similar, where they tend not to use that 2 year for terminating people, that short-term dismissal, but the SME market does, is high quality recruitment is going to be absolutely essential, making sure you're putting the right people in the right job and making sure you've got a watertight initial period or probation period, as we still refer to it, where you are doing one-to-ones and discussing performance, conduct, behaviours, and all of these things that might result in that person needing to exit. So they're the two biggest things that they're going to have to get right and get ready for. You got any thoughts on it, Kat?
I thought also that actually just the recruitment process, from the advertising of the role to actually the interviews to making sure that the person is suited as best you can for that role, having really whatever the initial period is that the government define. I think they're saying it may be as low as 6 months, but it could be up to 9. Making sure that you do have policies and procedures in place that, you know, spell out to the employees, this is what we expect of you during this period, this is what can happen if, you know, if it doesn't work out, these are the parameters that we're working in. And I think it's about having that clear dialogue with employees from day one. And also, if it isn't working out and you have fair reason, not being afraid to dismiss an employee, provided that you've taken advice from your HR consultant, or, you know, provided that you've sought some legal advice, or you're just familiar with the terms yourself and you're absolutely certain you're doing it correctly. But it all should be documented. It all should be, you know, although they're not saying how to dismiss somebody during that initial period, what they're saying is they do expect that there should be some kind of meeting that takes place where there's a conversation that's had with the employee, and that consultation or that meeting and the find. So it is about structuring the process with the new employee to ensure that everybody's clear from day one what can happen, and it means updating the disciplinary policy do with the employee's conduct as well. Performance reviews, you would need to look at that. Are you going to do earlier performance reviews? Are you going to do an appraisal sooner than you ordinarily would, in line with the initial employment period? So there are things to consider, and it may mean that your everyday policies at work do change. Period is a really good period just to start looking at, you know, where you think that might go and seeking some advice on it. But again, as always, another one to watch.
Yeah, and the reality is that even with short-term dismissals now, we encourage our clients to pick up the phone to us if they are looking to exit someone, and we will always have a conversation of best practice is ideally you've had a conversation already with them around what your concerns are to give them an opportunity to work on them. But the reality is that doesn't always happen, and we, you know, that is best practice. But one of the conversations we do have with employers is, can we double check there's been no whistleblowing raised, there's no, you know, anything that could diminish that 2 years, and it's not linked to a protected characteristic or disability or anything else that might diminish that protection period for the employer. So all it's doing is where we say it would have been best for you to have at least given them an opportunity to improve and had that conversation, that will actually become a requirement, I guess, in reality more than anything. And it would have, and that reasonableness test is what would come in. Are you being reasonable in your decision? Which, you know, as a solicitor, you always look at anyway. I know you always phrase it in a certain way around, was the you can probably word it better than I can, but was your decision fair and reasonable based upon the circumstance at the time? So but yeah, I think it's just making what we would refer to as best practice actually more watertight and mandatory, I guess.
And then, I mean, the next one, if we can move on to the next slide, I think, sorry, thank you. Again, I won't spend too much time on this slide, I don't think we'll need to, because we have got a lot to get through. I'm conscious of the time, but all these changes on the family-friendly rights side of things are quite small in comparison to others. So in respect of flexible working, I'm going to assume that people on the talk today are aware of what flexible working is, and that the employee can make 2 requests within a 12-month period to have flexible working arrangements agreed with their employer. And an employer has to look as to they've got 8 grounds that they can consider when refusing to give that flexible working request. That all remains the same. Nothing within the regime as it is changing. The only thing that's been introduced is that not only does the employer have to say what ground they're relying on if they refuse your request, they also have to explain how it was reasonable. So I think, again, another key thread of the bill is reasonableness. And now they can't just do something, they have to be able to back it up with a reasonable argument as to why it's needed. So again, in flexible work, and what they're saying is an employer has to be able not only to say this is refused because of ground, this particular ground, for instance, the grounds, I mean, there's 8 grounds, it's going to cost more money for the flexible worker request, or we can't recruit people to do the role when you're not here, or, you know, whatever the ground might be, they now need to explain that further. Made that decision to rely on that ground, you must already have that explanation written down somewhere. It's just about sharing that with the employee now. But other than that, I couldn't really see anything major in that regime that we need to really discuss. So that's, again, just a small change that we don't know when it'll come in, but it will be coming in sometime in the future.
Yeah, and you know, there was already major changes around flexible working earlier this year as well, where, you know, it became a day one right to request flexible working, which is why we said to our clients to be tighter on the recruitment and really know why they have to be at a certain location or doing certain hours. And obviously they can now request it twice a year. So I think the major changes around that has already occurred. And like you say, it's just now actually explaining under that definition why that decision was reached. So yeah, not a lot on that one. My next one around parental rights in reality, to be honest, there's still that's been hardly touched on. So under parental rights, we've got paternity leave and parental leave. The only real changes is that they're looking to remove the qualifying periods to be able to apply for them. So at the moment, you need 26 weeks to apply for paternity leave. They're looking at diminishing that and making it a day one right. And then obviously under the parental leave, it's currently a year service to be able to request that. They'll look at making that a day one right as well. But it's not being covered in the update, and we're still waiting for further information on that.
And it's the same with bereavement as well. So bereavement leave currently, the only legal requirement or the only legal obligation for bereavement leave is for a parent whose child has died, and that child has to be under the age of 18 and they're entitled to take time off work. What the government are trying to do with this new bill is to change the remit so that that's actually available to people who, you know, it's not a child that's died. The relationships, though, in terms of, because all it says currently and what I've read is a loved one, to grieve a loved one. What does that mean? Because different family dynamics and, you know, friends and people who we are close to who we would put into that category. So there's still some real work that needs to be done as to, although it's a broad statement, every employee should be entitled to, I think they're suggesting a week unpaid bereavement, but the definition as to how close in proximity to that person who's died you need to be is quite a delicate thing to consider as well, because even if the government bring in a definition, a guideline, I would suspect that an employer will often use its discretion, because you can't legislate for everything. You can't legislate for every relationship a person may have, or every significant relationship a person may have. So I think that probably is good, although there'll be a legal definition, that will be provided, I think there's probably going to be employers' discretion on top of that as well to go beyond what the government are saying as a minimum, which is probably going to be best practice for a lot of employers. Because we all have different family dynamics. So that's all that's really changing. Hopefully that everybody, not just parents, will be given the opportunity to take bereavement leave.
Yeah, no, I agree. And I know we have a lot of conversations, and most small employers normally give, the loved one. I know a lot of companies use the direct immediate family, but again, we always say double check the dynamics of the family, because immediate for them could have been a grandmother or an auntie or uncle raising them for whatever family circumstance reasons. And normally, we would recommend minimum 1 to 3 days. And then quite often we would recommend 5 or 10, and most of them would pay that when it's a very much close immediate family, if they need that time off anyway. So yeah, I think, like you say, that's probably going to be bringing in a minimum rate, a minimum statutory requirement, but a lot of companies go over and above that anyway from a pay point of view. So the right to switch off, there's nothing really I can share on that one. I know we talked about it at our last webinar, but there's nothing being put in. It's not being mentioned, other than it's to come at a later date. Other than that, no idea. So I know we've talked about it before and what that could look like, but we're still waiting on further information, as they didn't put anything in about that one.
I think that may be because, there was all those there was all those statistics that were published by YouGov saying, and I think it was something like 58% of employers were against the right to switch off and the right to disconnect, which as an employee, that can be quite shocking to hear. But then when you delve behind it to see, well, actually, certain positions within business do need to be contactable out of hours, such as managers or people in a supervising role or with extra responsibility. But I think the government's intention was to have a work-life balance, because the lines after COVID have become more blurred, with people working from home and it being okay to contact them on their own personal number, and kind of trying to separate the two has been difficult. And I think employees are kind of wanting that separation, and employers want to be able to rely on staff as and when needed. So I think that will be something that is perhaps not in, it doesn't even get added to the bill later, but perhaps separate legislation or instrument comes along, or a code of practice at least about best practices to maintain work-life balance. But you're right, it's not something that they've even included in the bill, and we spent quite a lot of time last time talking about it, trying to think, well, what those things that we thought it would be in, and it's not there anymore. And that's the same for going on to the genuine living wage. We that last time as well. And again, so there are things within the bill about wage, and there are things that are going to change, but everything we spoke about and considered hasn't been implemented just yet. So what has been is they've already changed the remit for the Low Pay Commission, so that they now have to, when they're considering and setting the minimum wage, they have to look at the actual living wage, and that has to be a factor that's taken into account when they're setting the minimum wage, which is great, because it's a reflection as to, the living wage, what the cost of living, what everybody can actually afford. So that's changed. And then what they're saying in a separate document called, I think it's the Next Steps policy, what they're saying, they are also going to change they want to introduce this genuine living wage in order to make it more accessible for everybody. And also that means reducing the national minimum wage parameters. So currently we have 18 to 21 over. They're saying that it will just start from as soon as you're an adult, 18 years of age, everyone should receive the same wage. And it shouldn't be, 18 to 20 should get paid less. It's just if you're an employee and you're over the 18 age, everyone should be on the same. But again, that's something that they're saying they want to introduce and will be introduced perhaps alongside the bill, but as a separate document, perhaps not even something that needs legislation to change, just legislation that's tweaked or a guide that's introduced. So that's something that employers need to be aware of, because it means if they've got any younger members of staff who are currently on the lower wage, of course, in the future, we all could be on that same baseline wage.
Yeah, and on this slide, people may spot that I've put national insurance on that line, even though that isn't in the bill. The reason I've put that on there is I'm not going to deny that as a business, a small business that supports other small businesses, the change to the wages that is due in April and ongoing, the national insurance, where they promised there wouldn't be any changes, and then there's this massive hit, and we're already starting to see the impact of these higher wage levels and the national insurance, where some larger corporations are already making announcements on cutting headcount and closing stores, and they're already starting to make changes. So the SME market do need to get a feel for where their wage costs and national insurance costs are going to go, because it is going to put more and more pressure on businesses. So that's a big worry for the small, especially the small businesses, from an affordability, and it's going to make people question whether they recruit and bring in new people or put more pressure on their current people.
I think in the next step policy, what they've said there is that any change would be a gradual change.
Mm.
So really went any further to explain how does that become gradual, because it doesn't, it seems they're reducing the bracket from 21 to down to 18, and they're going to put everybody on this living wage, but I don't know how you gradually, unless they're going to talk about gradually including it for different sectors or different industry. They haven't really explained how it's going to be a gradual change, but as of yet, they haven't even indicated when these additional next steps might take place. So it is employers, businesses who are budgeting and trying to plan for the future need to be aware of that, actually, and wages are going up. Like we were talking previously, Nikki, about in April, everything's going up, and the minimum wage that you're paying a full-time member of staff is something that perhaps some employers and small businesses can't afford. Um, everyone on the same wage at a full-time rate as well. So it is something to be mindful of, but unfortunately at this rate, there isn't really anything that we can do other than plan for it.
Yeah, there is. And I mean, I had a look at the wage increases over the last 4 or 5 years. And, for those who were always on the higher level, which was your 23 plus at the time, when you look at where their wages has gone, it's over £3 an hour. It's gone up, which was actually around 30 to 35% increase in the last 4 to 5 years on that higher age bracket. But when you think about they're going to bring this younger age bracket into line with what had been the higher age bracket, they're literally doubling the pay and more, so that's quite significant for a lot of businesses. And what worries me about that in reality is that there's going to be a preference for an older, more experienced market, because versus someone who may be younger and less experienced versus someone older with more experience, and they might only pay the minimum rate as a business, there's going to be maybe a bit of unconscious bias when it comes to the recruitment around that.
Yeah, there is definitely a risk of age discrimination in the recruitment process if the business is only offering or only able to pay that baseline minimum wage, that regardless of age you would receive. So ordinarily a person who's older may have acquired more experience, which means that if you go, you've got to pay them both the same. One's got more experience and one needs to invest more money to train them to get them that experience. There could definitely be cause there for age discrimination, which has to be really carefully thought through in the recruitment process. So the recruitment process is a key player here for a business to ensure that the person they're recruiting, you're doing it for the right reasons and you can justify all decisions being made.
Yeah, exactly. And and I think that'll certainly be a watch out for businesses in the future. Moving on to SSP and sick pay. So obviously a lot of the businesses we work with, we've got a few that pay company sick pay, but primarily I'd probably say 95 to 97% of our clients pay SSP. Now currently for SSP, they don't get it until day 4 because the 3 waiting dates. The employee's got to have a lower earnings limit threshold, so they've basically got to earn, currently I think it's around £123 a week to be entitled to SSP. Now the government are basically going to be bringing in that SSP will be payable from day 1. They're also looking at removing this 123 under lower earnings limit so that it would apply to everybody, irrelevant of what they earn, and there could be a percentage of pay that would be payable around that. They're looking at it including workers as well as just employees. They think the defined and the potential predicted payment of SSP might be around to 60 to 80% of earnings for those that may sit below the threshold, and what that might look like. So this actually, for me, is going to have a real impact on small businesses, because at the moment, the reality is for an employee who is genuinely not ill, they will think twice about going sick in the first 3 days because they know they're not going to get paid for it. And the reality is sickness management in small businesses is not the best. It quite often is something that's avoided for many reasons, whether that's knowledge or time. So sometimes, you know, when we can look at absence trends and levels within a business that we are brought in to look after, we can quite often pick up on high levels of absence that have never been managed. And we see that very much higher in businesses that pay company sick pay because people see it as additional holiday, unfortunately. So the reality is some people do. And I actually had this debate with a student recently that it was who asked about, why should I tell you why I'm off sick? And I had that, you know, and you should be paying. And her actual words used were, I am entitled to take time off and be paid for it for sick, and I don't need to tell you why. So we, you know, we had quite an honest conversation of the implications of that for her, in that a business can make a decision on their employment when they have no other information to go on, and they have the right to do that. So it actually is in her best interest to share the reasons why, in case she needs support and things like that. But this sick pay, the 3 waiting days where people don't get paid, it kind of worries me that that's going to lead to a big increase in the SME market of people that may have thought twice previously because it may or may not be genuine, or they probably could go into work or work from home, will actually now turn into people just going, well, I'm going to get potentially paid 60 to 80% of what I would have earned anyway, so I'm gonna phone in sick, and there'll be a big increase in absence levels within the market.
On the back of that, it is about having robust sickness management policies in place. So currently, you're quite right, I hear employers and employees, you know, this issue about being off sick. I've came across quite a lot of employees who are on long-term sick, and there's no follow-up, there's no contact. The employee doesn't know what to do. The employer doesn't want to do something it shouldn't, or discriminate against someone, or say something that it shouldn't. So everybody tiptoes around sometimes, especially if it's a long-term sickness as well. And I do think that there does need to be robust, and it's a great opportunity now to look at what we've already got in place. Do we have a robust sickness management policy in place? And, you know, look at the trends in attendance and absences. Do you operate a business where your employees are notoriously off sick? You know, where and what can be done to try and get on top of that, get ahead of the curve? Because yes, when the person's already off sick, you need to manage that sickness. But how do we prevent? How do we promote better health and work-life balance? How do we promote well-being? And so it comes to looking at everything is a whole, really. Are there support mechanisms that could be put in place? Can your business afford to have things such as an employee kind of advice line, or I don't know, coffee mornings where people can come and talk about things that are bothering them, or whatever it may be, or the things, little changes that can be put in place to actually minimize, if not prevent, the sickness, absence. And so I think all of those things, because do need to be considered. Otherwise, there is that real risk. Some people, unfortunately, will think, I can be off from day 1 and I will get paid, and could go into work. It's an opportunity for an extra few days off work being paid. and some people will take that. Not everyone, of course.
Yeah. Mm.
People, the other end of the scale is people drag themselves into work,
Mhm.
but they at home and their productivity's down, you know, they can't concentrate, but they feel pressured to go into work if they're genuinely sick. So I
Mm.
think there's a lot of work that needs to be done around kind of getting the balance right with that. But it is, you know, I echo your concerns. I think that is something that could genuinely have a detrimental impact on small businesses.
Yeah, and I know it's certainly something we've started looked at. So we've already started rolling out, and we're rolling it out gradually with our clients. We've been updating our sickness procedures because within the SME you keep it very simple, very relaxed, encourage conversations at certain points. But we're actually now starting to build in trigger points into our sickness policy around, you know, a conversation at first absence, making sure the return to work and the self-certificate forms are completed, and, you know, second occasion, third occasion. And we're going to be certainly introducing some masterclasses to our clients on how do you manage short-term absence, how do you manage long-term absence, what does the tone and the context of that first, second, third ongoing and that management look like. So it's certainly something we're going to be getting our clients ready for, to make sure that, but not just from a management point of view, but also from a welfare, making sure they're creating very much a safe working environment for their employees and supportive working environment as well, because those meetings are not about beating somebody up with a stick. They're about genuinely understanding why they're taking time off, is support needed, and us having the support mechanisms around them to manage that, either because they're all very random reasons, it's high impact on the business, or that person genuinely needs support.
And I
So
think this, oh, sorry, Nikki, I was just going to say this next one, I think we decided that we weren't going to cover
no.
anything with simply because we are talking about unions, we are talking about matters that generally may not be the focus of an SME market. So although they are all relevant and perhaps we will touch upon them in the future, but today's purposes, because we don't have a deal of time, we're going to leave the voice at work kind of.
Yeah, I think the only thing that when I was reading everything, and we're not going to go, like you say, there's very little impact to the smaller market on this. I think the one thing that will change, and obviously we will be doing this for our clients anyway, because for our retained clients, we automatically put all of the changes in place for them around their documents. But there will be in the future a statutory requirement to have a clause within the statement of particular and employment contracts that says they have the right to join a union. And obviously that will come under the unfair dismissal of less than 2 years if people are terminated on the back of that. So yeah. Again, the next one, we are not really going to pick up on this. We've talked about the pay. Again, some of this is very much around the larger players rather than the SME market, which we mainly focus on. But there is obviously a number of changes that are going to be coming in, and if we need to touch on them in the future, we will. The next one is around rights at work. Now, employment tribunals, I'm going to be honest, I think they're on the verge of breaking, Kat. We are seeing a real increase. We've seen a real increase in employment tribunals this year, primarily around neurodiversity. We've seen a lot of conflict in ACAS conciliations and claims come in this year. In fact, I'd probably say about 80 to 85% of ours have come in this year. We've seen a big increase, but we've also seen the way that ACAS and employment tribunals handle them is very different. So we've noticed on the ACAS website, when people lodge their intention to bring a claim and go for ACAS conciliation, there's a new little tick box that's appeared where employees can now tick and say they don't want to conciliate and they just want their certificate to go straight for a tribunal. Whether that's a time and cost saving process for ACAS, who knows? It just suddenly appeared, and we only discovered that when you and I had a talk about this ET1 came in and we needed to get an ET3 done for a client, and it was like, well, we've not even had conciliation from ACAS. And when it was discussed with them, they went, oh yeah, there's a box on the website now, they can just tick the box and get the certificate straight away and skip that whole process. But obviously once an ET1 comes in, that's quite a costly process for employers in a very short time frame to then be getting an ET3 response done, which is costly, time consuming, and you have to have the knowledge to do it. The employment tribunals, we're also seeing a change in the behaviours of ACAS. So we're seeing them less warm, less friendly, a lot more direct. They're supposed to be impartial, but we're starting to see that they're starting to not be impartial and take employees' sides and starting to be quite direct in their approach. So, you know, there is a whole lot of changes with the employment tribunal, and because the 2 year is going to be diminished, people are going to be able to bring so many claims for unfair dismissal from day one. Now, we absolutely know, and we've come across them, there are serial claimers, and you only know they exist when they've gone to tribunal and it's case history on the government website. But when they're doing settlement agreements, or whether they are doing it via ACAS conciliation, we can't see the records of these people. And I absolutely know there is serial people going for jobs that they know they would never get and bringing claims at the moment. I've come across them within our peer group. So I'm worried about the volume and employment tribunals. They've actually said at the moment they've got no plans to increase their headcount or resource, and they're already on the verge of breaking. I mean, I know a friend of mine that brought a claim recently with ACAS. She submitted her ET1, and it's actually took them about 9 weeks to confirm that they've even received it. So, you know, the average time frame of getting a hearing varies from around the country, but there's no plans to increase the resource. I think they're going to break, and I'm even seeing some solicitors and lawyers being very vocal about this on LinkedIn. I was on a stream the other day where I commented, this is something I've been talking about in our peer group. So it's nice to see that we're seeing some mirroring within the legal fields, that they're also worried about the employment tribunals failing on this. Certificates are getting issued straight away. Could it lead to other processes being put in place around mandatory? So, for example, where we get a claim at the moment for someone who goes for unfair dismissal and they don't have the rights because they haven't got the 2 year limitation, that still has to go preliminary hearing for you to request that it's been thrown out on that basis. Are they going to bring something in intermediately that stops it even getting to that point to reduce the processes, and more putting in place mandatory mediation and settlement prior to preliminary hearings, and trying to maybe manage some of that? I'll be interested in your thoughts on it, Kat.
Well, I think the other thing that's running alongside all of those things that you've just mentioned, Nikki, is that in the bill, well, in the Make Work Pay guide, they had proposed changing the time limits as well, didn't they, for the tribunals? An employee, in most cases, not all, but in most cases, will have 3 months less 1 day from the date they're dismissed or the date something's gone wrong to get their claim at a tribunal. The Make Pay document suggested that that would be increased to from 3 months. Employee to conclude all of the internal procedures such as appeals and things like that with their employer, to have real discussions about negotiations and settlements, and to also for the employee to generate enough funds to be able to instruct legal counsel to assist them in a tribunal. So those were all of the kind of positive reasons that the government said that they wanted to increase the time limit. But then the bills came around and there's no mention in some next step documents saying this may be something that's looked at further in the future. Now, it is a two-edged sword, really, because you're a double-edged sword, because it allows everyone more time to negotiate. It allows tribunals more time to process things, because there's, you know, not everyone's trying to do it in 3 months. So it may generate, you know, free up some resources, or at least give everyone a breathing space. But then on the flip side, you've got an employer who's let someone go and they've got to wait 6 months, that uncertain period as to whether or not they're going to be sued, whether or not they need to start throwing resources at something that happened such a long time ago, because 6 months, a lot can change. So They haven't actually introduced that yet, but I think that goes hand in hand with what you're saying about other tribunals on the brink of collapse, or are they so, because the courts in general, there's so many delays. You're talking 16 weeks sometimes to get a response back. So I think there's going to be a huge overhaul of all of the court system, including the tribunals.
Mm.
But the bill unfortunately doesn't really seem to do anything to ease the strain and the pressure. And we're given employees are going to be given more rights
Mm.
early, rights earlier, which means there's a real risk that more claims could be brought. And if they're not in resources that are already stretched, we are going to see huge delays. If not, if the claims still go through, but they're taking longer, it's that uncertainty for everybody involved for a long period of time.
Yeah, like you say, the 6 months, I know we discussed on the last one, we suspected that the 3 month time limit would go up to 6 months. We would obviously get longer to start doing, and we know when a tribunal's going on, we can always go through and settle under Cut 3 with ACAS and everything anyway, even before hearing takes place. But I have no doubt that we would see nothing less than at least a 30% increase in employment claims hitting us once all of these changes come into effect. And I know there's been prior talk before about bringing in fees again as to whether people are fees, but a lot more reasonable than they've done it last time. But again, there's silence on that at the moment. So, but they are going to have a look. I mean, I think there's so much noise around the tribunals and courts are broken, and they need to make changes and invest in the resource and their processes. I think they're not going they're going to have no choice. They're going to have to, but they're just not being honest about it at the moment.
And I think also it's to remember from a business point of view that a tribunal claim is the last resort.
Yeah.
Going to capacity is always the last resort. So can conversations be had between that, it gets to that stage for settlement? And when we're talking about settlement agreements and settling a claim that comes through, it isn't to say that the employer's done something wrong or that they're at fault in any capacity. But unfortunately, if you're on the receiving end of a claim, if it doesn't settle, you're going to be incurring considerable fees to get it all the way, excuse me, to get it all the way to a tribunal. And even if you win, you're unlikely to recover those costs back. So sometimes the better approach is an economical decision about what is the quicker, cheapest way to get this sorted
Mm.
with keeping your reputation intact, controlling the narrative. So with a settlement agreement, for instance, you're controlling that. No one can talk about it, can't say anything derogatory about you. You're not admitting any liability. You're basically paying them a small sum of money instead of paying a lot of money in legal fees later down the line. Excuse me. And so I think all of those things about, yes, the tribunals are struggling, the court system's struggling, but what can we do before that to avoid that happening? Because sensible conversations
Mm.
can take, and it's about being open to the possibility of doing that.
Yeah, and we do a lot that. I think also linking into this, they talked about bringing in a new governing body that would take the unlawful deductions of wages off the employment tribunals and have a separate entity that manages unpaid holidays, unpaid pay, things like that, because some of those can be managed so quickly, trying to take it out of those processes and creating something a lot simpler around unlawful deductions of wages. Okay, safer workplaces and harassment, Kat.
Yeah, and I think this is our last topic, isn't it?
Yeah.
Again, there's been a lot of publicity on sexual harassment in the workplace. I mean, recently the law changed at the end of October that now places a positive duty on employers to take reasonable steps to prevent sexual harassment in the workplace from employees and third parties. What the bill is doing is simply all the bill's done is added an extra word. And so what they're saying is instead of an employer having to take reasonable steps, they must take all reasonable steps. So
Mm.
although it's a small word, it's a big change because that's so, it's open to interpretation. What does all reasonable steps mean? As we've seen with everything else in the bill, it's still going to be subject to consultation. That has not been defined. Reasonable steps are likely to be defined further in further guidance. Like there's already been guidance published.
Mm-hmm.
Well, Equality and Human Rights Commission, but what they're saying is they're going to extend upon that to make it harder for employers to defend things that happen, and they really need to have best practices in place to ensure that they have taken all reasonable steps. So that includes risk assessing situations, ensuring people are safe at work, people know how to report harassment, know everyone who's engaging with your business know that you have a zero tolerance policy to sexual harassment. And it's about making sure everyone's very aware and understands what sexual harassment is as well, because unfortunately, it can be, it's not just inappropriate touching, it could be in general, because it's not what the person who say, I give you a hug, Nikki, it's not that I intend that not to be anything untoward, but you might be offended by me hugging you, and that could be seen as sexual harassment in the workplace. So there's a lot of work that needs to be done in order that people understand what sexual harassment is. And then, first of all, we need to understand what it is, because if we don't know what it is, then we can't take reasonable steps to prevent it. And as I say, it is a small change in terms of the wording, but it has a big impact on employers, because the burden is very, very heavy on an employer. Because you're not even just talking about controlling what happens within your own organisation with your own staff. It's interactions with third parties, which is the big sending off. Your employees might be going to an event, might be going to a networking event, might be going to a training session, whatever it is, might be interacting with people that come into the business, customers, clients, whatever. Your responsibility as an employer is to make sure you've taken all reasonable steps to avoid sexual harassment. So that's something that's going to come out further with further guidance and through consultation. So the law only recently changed in October. We're all still getting to grips with that change, but it's just mindful that there is actually more change on the horizon.
Yeah, there is, and that's a big piece of work we've been doing with our clients since October. We've been running, harassment training for managers, harassment training for staff. We've been providing them with the training, or delivering it for them if they don't want to run it themselves. And we've introduced risk assessments and lists of what is all reasonable steps. What do some of the top barristers in the UK believe all reasonable steps look like in relation to what you need to put in place? And I know we've been doing a lot of work with our clients around that, because I think there's been a big underestimation around the liability historically on that. So, we've had a real emphasis on that and updated all of our client policies and everything on that. So, I guess the final one now is, bear with me, my computer's thinking about whether it wants to move slide or not. There we go. So I guess some final things, and we're not going to go into, I think, masses of detail on this. There's a couple of things that have disappeared. We've touched on them briefly, which was the extension of time limits. That's disappeared. There's been no mention of that at the moment. And obviously miscarriage leave had been mentioned in the Make Work Pay, which wasn't showing. And then we've kind of got things where they've touched on it, expected, not covered, or things that other things to mention. So I guess some other things to mention is obviously things that have not been included in the bill and will probably be separate legislation or non-legislative will be the right to disconnect, the supporting workers with a terminal illness through the Die Into Work Charter, modernising health and safety guidance. I know that we're talking about things like putting in limits around high temperatures and temperatures in the workplace, which are very lax within the health and safety guidance at the moment. Ensuring the public sector equality duty provisions cover all parties, developing menopause guidance for employers and wellbeing, extending the pay gap reporting, extending equal pay rights, ensuring outsourcing of services can no longer be used by employers to avoid paying equal pay, and implementing a regulatory and enforcement unit for equal pay with involvement with trade unions. There's other parts that I think the government have got a longer term vision on as well, which is around the parental leave review, carers leave review, surveillance technologies and negotiations with trade union and staff, single worker status. They're going to be looking at strengthening protections for self-employed through a right to a written contract as well, and extending blacklisting protections and around health and safety. Further work around TUPE, reviewing health and safety guidance and regulations, raising collective grievances, procurement systems and reform, and the Freedom of Information Act. So they're all some of the future things that we know is going to come at some point, but they're certainly not anything we need to cover right now. So I guess some of the next steps that I'm probably going to be saying to people on this training that they need to start think about is where we've talked about a lot of these things today. If you haven't reviewed and updated your policies, contracts, please review them, update them, get them rolled out. And we do recommend, especially the equal opportunities, the bullying and harassment, the disciplinary and the grievance is at least reviewed annually. I know that's something we do with our clients. Ensure training around the harassment and the sexual harassment is being done not just for managers and staff, and they're two separate trainings and sector specific as well, because that is pivotal for businesses now. Obviously, that's something we can help with if people want to reach out to us and discuss what we do. And obviously, we have recorded this session, so we will, once we've had a look at it and amended it, we will obviously send out any contacts, any information, recommended next steps, and things like that. And I guess the final one is handing back over to Zoe.
Thank you. Excuse me. So can you hear me all right? Sorry, I got kicked out halfway through.
Yeah,
and
we
just
can
had
hear
to
you.
come back. Thank you. So thank you so much, Kat, Nikki, for such an informative webinar. Some amazing things that we haven't even thought of. Has anyone got any questions? Would you like to either put your hand up using the little tool, or you can use the chat, or even if you would like to unmute and shout out, I'm happy with that as well. But I'll just open the chat and be ready if you've got anything. Just trying to see if we've got any hands up.
We won't be if there aren't any questions.
No, looks like we've covered a lot of things that we might obviously. We're going to share some of our information in a moment anyway. So if people think of things afterwards, they'll have an email for Kat or they'll have an email for us, and they can contact us. And our clients can obviously reach out to us as well. So it doesn't look like we've got any questions. Not seeing anything.
That's great.
Good. And then the final one is for any of those that are Northeast based, we have our next event on Tuesday where we have some fantastic local businesses that are going to be doing some inspiring speaking for us. I will also be launching my podcast there. There's going to be gifts, there's going to be Prosecco, there's going to be cakes. Kat has done a wonderful podcast. She's one of my first 6 podcasts with me. So thank you for that, Kat. We had really good fun talking and debating some of the things that were coming around and why we work together. So we had a really good chat there. The QR code is on there. We have a few tickets left and there is a limit. So if you want to attend and network with around 50 other businesses, get to meet 50 other businesses, listen to some great local business owners and speakers. And Zoe will be interviewing me as part of my podcast launch as well. No pressure there, Zoe. Then do come along and join us. And then the final one is thank you for attending. There's our contact details if anyone's wanting to reach out to us afterwards. And I will hand back to Zoe to tie up.
Yeah, that's everything. I was just going to say exactly what Nikki said about the event. I'll email it out to you all as well. Hopefully we'll see some of your local folk there next week. If any questions pop into your head over the next couple of days, you've got our contact details. Please reach out. And yeah, I hope you found it all very informative. Thanks for all the comments, and we look forward to seeing you at another webinar soon.
Thanks,
Thanks everyone. Bye-bye.
Thank you. Thank you. Bye-bye.
Okay. All right. Yeah. No, that's fine.
Thank you.